want to welcome everybody to today's webinar on negotiating physician employment agreements. My name is Susan Hunt, and I will be moderating today's webinar. If you have questions for our speaker, please use the Q&A button at the bottom of your Zoom screen at any time. We will address your questions as time allows at the end of the presentation. Now, please allow me to introduce our speaker, Trey Hendershot. Trey is managing shareholder of Hendershot Cowart P.C. He has been representing physicians and healthcare entrepreneurs since 1987. In that time, he has reviewed and negotiated thousands of employment agreements and is familiar with the loopholes and weak points that may lead to trouble down the road. Trey's clients describe him as professional, knowledgeable, and attentive, and they characterize his years of experience and expertise as invaluable. Thank you for speaking with us today, Trey. The floor is yours.
Thank you, Susan, and thank everyone for joining us today. I appreciate you being here. Just to quickly go over what our agenda is for this discussion. First of all, we're going to hit what the key elements of a physician employment agreement are, the things that you should look for and make sure are included in an agreement. And then we're going to talk about compensation formulas. And I know that's an area that's near and dear to everyone's heart. Then we're going to talk about the restrictive covenants, that proverbial non-compete. We'll talk about the termination provisions and various dispute resolution provisions and what those actually mean. And then at the end, as Susan said, we'll open the floor as time permits to any Q&As that you might have. So first of all, yes, as Susan said, I am a lawyer. I've been doing this since 1987, but please remember, I am not your lawyer at this time. The information that we're giving in this webinar is general in nature and for informational purposes only. Nothing in these slides is to be taken as specific legal advice. It's important to remember that each contract, each fact situation turns on its own terms. And so we need to look into each contract specifically before any legal advice or legal conclusions are given. Further, the viewing of this webinar does not form or constitute the attorney-client relationship. Okay, key elements of a physician employment agreement. These are the things that you need to look for and that are usually contained in a physician employment agreement. I tell people routinely when I'm reviewing employment agreements for them and consulting them on them that over the last 36 plus years, I've truly reviewed, negotiated, litigated, arbitrated thousands of physician employment agreements. And so you learn what is usual and customary in those agreements, and you learn also where the pitfalls are. So some of the things that we want to focus on, first of all, what are your duties? Now, this is critical because going into the negotiations of a physician employment agreement, two things that you need to have in mind and you need to understand. Number one, what are your ultimate goals? Where do you want to be? What do you want to accomplish out of this employer-employee relationship? And so the duties that are being imposed upon you and that you're agreeing to abide by are going to be very critical for you to implement that with your personal goals. The other thing that is going to be very important is when we get to the compensation aspect, to know your worth, know your value. So in an employment agreement, there needs to be a section in there that spells out what your duties are. And a key landmine, I will call it, is when the employment agreement contains language as and such other duties as the employer in their sole discretion may require. Well, that's a problem. And that's one of those pitfalls that we want to make sure that when we're reviewing the employment agreement, that we eliminate that language where it says in the employer's sole discretion with your duties. The other thing you want to look to in your duties is language that continues to allow you to utilize and implement your own independent professional medical judgment. Anytime that your judgment is limited, that becomes a problem. And so we don't want the employer to have an ability to terminate your relationship, terminate your employment, if you are exercising your own independent medical judgment with respect to patient care. Another thing that is critical in any physician employment agreement, it will say, is it full-time? Is it part-time? Well, make sure the hours that you're planning on working, and if you're going to have to do shifts, if you're going to have to provide call coverage, make sure that that's clearly defined in there. Because one of the things that we see that is a loophole that employers many times utilize is language on call coverage or language on shifts, to where they say the schedule will be determined by the employer in its discretion. Again, that doesn't give you any assurance of when you're going to have to work and when you're going to not have to work. If it allows the employer to establish the shifts without any parameters on that, you can end up with every holiday and every weekend being the new kid on the block. The next big area is compensation. How much are you going to be paid? Most physician employment agreements contain a component for a base salary and a bonus. Now, the base salary is usually a set number, X number of dollars per year. And this is where knowing your worth is very critical. There is a lot of information out there that can be obtained. And since we have reviewed so many employment agreements, and we also subscribe to a number of surveys that give us substantial data on what is compensation. For example, if we're reviewing your physician employment agreement, we can tell you whether or not the compensation you're being paid is within the 25th percentile, the 50th percentile, the 75th percentile, or the 90th percentile. And if you have an agreement that says your compensation is X dollars per year, and when we do this analysis, if we have the data to support it for you, we can tell you, okay, you're only in the 25th percentile based upon the compensation that's being paid. And using this data provides a very strong leverage point for you to go back to a potential employer and say, look, based on such and such data, I'm only being paid in the 25th percentile or less than the 50th percentile. And so it gives you an ability to negotiate upwards to say, well, if I was being paid the 50th percentile, it would be X. If I was in the 75th percentile, it would be Y. And so this adds a strong negotiation component for you by, again, knowing your worth. Bonuses. Many times bonuses are calculated based upon wRVUs or on some formula. It is critical, absolutely critical, that bonus formula be spelled out in clear and concise terms so that you understand it. And more importantly, so that it's easy to enforce in your favor if you don't believe that you're being paid the right amount. One thing that we always insist on with respect to bonus calculations or any compensation calculation is an ability to inspect the employer's books and records as they apply to your services, as they apply to your collections. That way you can ensure yourself that you're being compensated appropriately. In my 36 years of doing this, the two largest areas that we get into litigation or arbitration over employment agreements are number one, with respect to non-competes, and number two, compensation. So having a clear, defined compensation formula is critical. Our next key element with respect to the employment agreement is benefits. What benefits, in addition to your compensation, are you being provided? Are you receiving health insurance? Does that health insurance cover just you, or does it cover your dependents? How much vacation are you getting? How much are you being allowed to attend CME conferences? What allowance are you given for your CME throughout the year? Is there a retirement plan? What type of contributions will be made to that retirement plan? These are all critical components to the employment agreement, because one of the things on benefits, and I hear this routinely, well, when I was interviewing, they promised me X. Well, unless it's specifically provided in the employment agreement, it doesn't matter. You will not get it, because most physician employment agreements contain what we call a merger clause at the end of the contract. And that's a clause that says, unless it is specifically set forth in this agreement, it's waived. And this agreement provides our final negotiated agreement. So it's critical to make sure everything that you've been promised, everything that you've been led to believe, and everything necessary to meet your goals is specifically included in the agreement. Next is intellectual property. Some of you will be engaging in research. Some of you will be writing articles. Some of you will be coming up with various types of patents and intellectual property. It is critical to look into who will own that. Some of you will actually do that on your own nickel and on your own time. And so we want to make sure that there are provisions in the agreement that if you are doing the research, if you are developing the intellectual property separate and apart from the employer, that it remains your property. Most agreements will contain what's known as the work for hire doctrine. What the work for hire doctrine does is it says that if it's developed, if it's intellectual property and it's developed utilizing any of the employer's resources or while you're on the employer's time, so to speak, then the employer owns it. Another thing that we need to look for is for those of you that have been in practice for a few years, you may have your own intellectual property that it's already been developed. And if that's the case, we need to make sure that when you're negotiating that employment agreement, what is your intellectual property is carved out, especially if there's a work for hire doctrine included. A subject area that I get asked about routinely is what about other outside activities? Can I moonlight? Can I serve as a medical director? Can I have a call coverage agreement? Can I testify in legal malpractice cases? Or excuse me, in medical malpractice cases? And most employment agreements contain language that says that you cannot engage in any outside activities unless the employer gives their prior written consent. And then many times the agreements provide that any revenue that's generated from these outside activities will belong to the employer. So if you're looking to be able to have, for example, a medical director agreement, or if you're looking to have a call coverage agreement, and you're expecting that the income from that goes to your compensation, that has to be expressly spelled out in the employment agreement itself. Now, this is something that we're starting to see a lot more of. In the old days, it used to be the only outside activity that people really worried about were an ability to testify in medical malpractice cases. But now, especially with all of the med spas popping up and the IV hydration clinics popping up, where people are wanting to serve as medical directors for those entities, we're seeing a lot more of this where it becomes necessary to ensure that the agreement allows you to engage in those activities, that you're covered by malpractice insurance, and you're entitled to keep the income that comes in off of that. The next thing is going to be the term and termination. And so what the term means is how long will the agreement be in place? Is it 1 year? Is it 3 years? Is it 5 years? And then does the agreement have what we call an evergreen clause? And what an evergreen clause is it says this agreement will renew automatically for successive 1 year, 3 year terms, unless either side gives notice of non-renewal in advance of the termination of that particular term. And so that's one thing you need to look into, because if you're moving across the country with your family, you're not going to want to make a move and reestablish a home where the agreement can be terminated in a year's time, where the agreement can be terminated in less than a year's time. And that takes us into the termination provisions. And what the termination provisions are these are the provisions in the agreement that allow either the employer or the employee to terminate the agreement. And so many things that you'll see for the employer to terminate are if your medical license is suspended or revoked, or if there's any restriction placed on that, if you're uninsurable, if you are subject to a peer review proceeding at a hospital where you have credentials. Many times those are included, and what we always want to see is if something like that is included for a termination of your agreement, we want to make sure that it's only after notice and a final determination is made. especially if it's a peer review proceeding. We want that to be a final peer review decision before you can be terminated. Also, you'll see language in there about a breach of the agreement. If you fail to do what the requirements are under the employment agreement. Now, it's important that if there are breach termination provisions, that they be made mutual. That means that the employer can terminate after written notice and opportunity to cure, but also you as the employee should be able to terminate if the employer breaches the agreement. The next thing is going to be with respect to insurance coverage. What type of insurance is being provided? Is it claims made or is it occurrence-based insurance? Now, many people say, well, Trey, I don't know the difference. What's a claims made policy or what's an occurrence policy? Well, a claims made policy provides that the policy period is from, let's say, January 1 of 2023 to December 31 of 2023. And so what would happen on a claims made policy is the event would have to occur during that policy period, and a written notice of the claim would have to be received during that policy period. Thus, a claim made during that policy period. So if a policy period was from January 1, 2023 to December 31, 2023, and the event, let's say, happened in October of 2023, well, then there's the event. But if the demand wasn't received until March of 2024, it would not be covered by a claims made policy. And so you would have to then acquire what's called extended reporting coverage, more commonly referred to as tail insurance, if your insurance is provided on a claims made basis. Now, the other side to that is what's known as an occurrence-based policy. Same example. If the policy period is January 1, 2023 to December 31, 2023, and the event happens on October 1st, 2023, it doesn't matter when the claim is reported or the claim is made, because the occurrence happened during the policy period. Therefore, you do not have to buy extended reporting coverage, tail insurance, for the applicable period of the statute of limitations. And understand, the statute of limitations is 2 years unless you're dealing with minors, and then there's an extended time for that. But you would have to have tail insurance if you had a claims made policy. The next thing that we look for is indemnification. And this is a provision that you have to pay very careful attention to. Because what indemnification means is if I do something that causes liability on you, then that means I have to pay for it. I have to indemnify you and hold you harmless. Most employment agreements have language, very detailed language, that says if the employee does anything that causes liability through intentional act or negligence or otherwise, that causes liability upon the employer, the employee is required to indemnify, pay for it, if you will. But what we always want to do is we want to make sure that there's mutual indemnification. So if the employer does something that causes liability to the employee, then there is reciprocal indemnification for that. Okay, Susan? Base salary. This is what we were talking about a moment ago. And what are the comparisons? In order for you to know if you're getting an appropriate deal, if you're getting the right salary, you need to know what the comparisons are. You need to know what other physicians of your specialty, your time in practice, and also your geographic location are being paid in order to be able to effectively negotiate a salary. Otherwise, you are simply at the proposed employer's mercy, if you will, and you're wondering, am I being paid enough? And this is one of the areas that when I'm reviewing employment agreements for physicians, that probably 90% of the agreements that I review, I get asked the question, is my compensation appropriate? Is my compensation usual and customary? Is my compensation fair? And so it's critical to have that information just to know where you stand. Now, you may be in the 90th percentile, and if that's the case, it's hard to negotiate going up from there. But at least you know where you stand. The next thing, as we've talked, is the bonus structure. And we see bonus structures calculated in many different ways, but they're usually some form of productivity-based formula. It can be based upon wRVUs. It can be based upon collections. It can be based upon patient satisfaction surveys. There are many different formulas that go into the calculation of productivity formulas. And this is where it's critical to ensure that there's transparency, that you have the ability to, number one, understand how your compensation and your bonus is being calculated. And number two, that you have the ability to verify that. And the best way to verify that is to have language in your agreement that allows you to have access to the applicable books and records that are utilized to calculate your bonus. The next thing that you'll many times see, if there is a productivity-based formula on the bonus, is a reconciliation. And what happens many times on this is you're paid an estimated bonus, let's say quarterly. And then at the end of the year, there's a complete reconciliation done to determine if you've been paid enough or if you've been overpaid. And usually there's language that says if you've been overpaid, you have to pay it back within a period of time. But what we also want to make sure is that same type of language is included for your protection, to where if you've been underpaid on the bonus, that it gets repaid to you the amount of the underpayment within a defined period of time. The next thing we look to is wRVUs, and this is becoming more and more popular for the calculation of productivity bonuses. What you need to make sure is that the amount that you're being compensated is clearly defined. The value of the wRVU is being defined. And again, this comes back into the same thing as base salary comparisons. Is the amount that you're being compensated for each wRVU, is it the 25th percentile, 50th percentile, 75th percentile, or 90th percentile? Is it a usual and customary amount for your geographic location? So these are all things that when we review physician employment agreements, we can sit down and we can do the analysis and we can give you the data in order to determine whether or not that bonus amount that you're being paid is in fact a usual, customary, fair bonus amount. Recruitment agreements. These are utilized many times when a new physician is being brought into a hospital's service area. And they're tricky because usually if you're joining a group, the money from the recruitment agreement has to be turned over to the group, and they use that to fund your salary. But the problem is, because of the anti-kickback statute, the money that is funded pursuant to a recruitment agreement has to be repaid to the hospital. And so usually what you will see is language that says that if you stay in the service area for a period of 36 months after the initial payments are made under the recruitment agreement, that 1/36th of the amount of the payments that were made would be forgiven each month. And that sounds okay, that's pretty good. But the problem is, even if the medical group ended up getting the money, you as the individual physician get a 1099, hence tax liability on those amounts that are forgiven, and that sneaks up on people many times. The other thing that we want to make sure is that if there's a recruitment agreement, that the practice that you were joining signs off on that agreement also, and that they have joint and several liability. And that's critical because if your employment is terminated and the practice did something wrong as to why your employment was terminated, you want to be able to hold them responsible for that repayment as opposed to you having to be solely responsible for that repayment. Non-competes. Again, this is probably the largest area where we get involved in litigation, and it's one of the areas that we have to pay very careful attention to when negotiating a contract. In Texas and in all states that allow non-competes, in order for a non-compete to be enforceable, it has to meet certain restrictions and certain criteria. In Texas, that criteria is, number one, it has to be ancillary to an otherwise enforceable agreement, hence an employment agreement. Number two, the scope of services has to be reasonable. And so it can't exclude you from services that the practice doesn't have any realistic reason for excluding you from. It has to contain reasonable geographic restrictions. It can't say throughout the entire state of Texas. It has to be reasonable in its duration. How long will it last? And this is one of the things that we really negotiate into a non-compete of when it will be applicable and when it will not be applicable. Because if your employment, let's say, is terminated by the employer without cause, why should you have to pick your family up and move out of the geographic area for the duration of that non-compete if you didn't do anything wrong? And so this is where we get involved, and we help physicians routinely negotiate their non-compete, negotiate the language that goes into the non-compete, and negotiate the exceptions to the non-compete so that you have some protection also. In Texas, for a non-compete to be enforceable against a physician, it has to contain a reasonable buyout. Well, what is that number? What is a reasonable buyout? Well, the statute provides that it can be determined by an arbitrator. Well, that's expensive. And so usually you want to have a defined amount included in the contract, in the agreement, right from the get-go as to what it's going to cost you to buy out. And that agreement needs to contain an amount that is fair and reasonable. Now, what's fair and reasonable? Well, the employer is going to look at that substantially different than what the employee does, because the employee is the one writing the check. So again, with as many of these as we've reviewed and negotiated, we can tell you pretty well what the standard amounts are when we're reviewing that agreement for you. Further, in Texas, in order for a physician non-compete to be enforceable, it has to provide you with access to patient records, and it has to also provide that it cannot interfere with your providing treatment to a particular patient during the course of an acute illness. The next thing is confidentiality. Well, how broad is that confidentiality agreement, and what does that actually include? So that is one thing that you want to pay very careful attention to, and you want to look into what are exceptions to confidentiality. For example, if the information became public knowledge through no fault of yours, you shouldn't continue to be bound by a confidentiality agreement. Non-solicitation. Well, non-solicitation will come in two forms. There'll be non-solicitation of other employees or providers for the practice, and there'll also be non-solicitation of patients. Now, in Texas, the medical board requires you as the physician, if you are changing your practice location, to give notice to your patients. And so this is one area that many times comes into question is, what can I do to comply with the medical board so that I do not violate the non-solicitation of patients in my employment agreement? So that's where it's critical on the front end when you're negotiating that agreement to make sure that there's language in there to protect you based upon the obligations that are placed upon you by the Texas Medical Board. Termination provisions. And this is one thing that we talked about a moment ago. We want to be careful anytime the termination provisions say that something can be done in the sole discretion of the employer. That means they can be acting as arbitrarily as they want to, and you can't do anything about it. So anytime you see the language sole discretion, that's a big red flag. That's something we need to look into. That's something we need to negotiate out of the agreement. And there are other options that can be put in that help protect you other than the sole discretion. Another thing is we see many times employment agreements allow the employer to terminate if you're not acting within their policies. Well, that's why it is very critical, as we talked earlier, in addressing your duties and your responsibilities to make sure language is in there to where you at all times will have the discretion to exercise your own independent medical judgment. Because we don't want the employer to come along and adopt some policy that interferes with your medical judgment and thus leads to your termination for a breach of the agreement. You'll many times see that an agreement can be terminated for actions that endanger a patient or reflect poorly on the practice. Well, this is ambiguous. What does endanger a patient mean? What does reflect poorly on the practice mean? And so what we want to see in situations like this are the ability for you to have due process, just like in hospital medical staff bylaws. If somebody's going to say, well, what you did reflected poorly on the practice, it needs to be more than a one-person decision, and there needs to be due process with it. And the same holds true for an indifferent attitude. What's an indifferent attitude? This is something, again, that is very ambiguous, and you need to have due process with that. Or what I prefer, actually, is when I see agreements that contain language about you can be terminated for an indifferent attitude, to strike that language in its entirety. Now you have termination with cause versus termination without cause. And with cause means there was an event that occurred that is defined as cause. Without cause just means on X number of days written notice, either you or the employer can terminate the employment agreement. Without cause termination provisions, I many times tell clients, well, that's a two-edged sword, because if you get somewhere and you don't like it, you may want to be able to exercise that without cause termination provision where you can go elsewhere. However, the flip side to that is if you go somewhere and they don't like you, they can terminate without cause, and then you may have picked your family up and moved across the nation, and all of a sudden what you thought was a 3-year contract has turned into a 30-day contract. So without cause can be debated from both sides, but what it does need to contain in your employment agreement is it be mutual, not just that the employer can terminate without cause. If the employer has that right, you as the employee should also have that right on the same notice period. Dispute resolution. Everybody's heard of a lawsuit and run down to the courthouse and file a lawsuit. Well, what we're seeing now in most physician employment agreements is language that requires arbitration. And arbitration is substantially different than litigation. Litigation, you go down to the courthouse and you appear in front of a judge, and there's the rules of civil procedure that tell you how things will be conducted. Well, while arbitration does have some rules, it is in front of an arbitrator, and it usually takes place being administered by either the AAA, the American Arbitration Association, or the National Health Lawyers Association. The issue with that is, in arbitration, you have to pay whatever agency is conducting it, and you have to pay the arbitrator. And the arbitrator is usually an attorney. And there are very few reasons that you can appeal an arbitration. So you're giving up rights. You're giving up the right to a jury trial. Mediation. Many times people get mediation and arbitration confused. What mediation is when you and the other side appear in front of a neutral third-party mediator, and the mediator tries to facilitate through discussion the settlement or a final agreement between the parties. What we are seeing a lot of times now in employment agreements is language that says prior to any legal dispute, prior to any arbitration, the parties will attend mediation in an effort to try to resolve their differences. Okay, that takes us through it.
Yeah. Thank you so much. And now we are going to open it up to questions. As a reminder to our audience, if you have a question, please use the Q&A feature at the bottom of your Zoom screen. Now let's touch on some of the questions that were submitted during our presentation. Trey, have you noticed a gender pay gap in the agreements you've reviewed?
Actually, we have. And in years gone by, the gender pay gap used to be substantially larger than what it is now. One of the good things that we are seeing now is that pay gap is, the gap is decreasing, and we don't see as much of it. But this is one of the things that comes into what we talk about know your value. Know what the surveys provide compensation should be. That way, you know if you're being compensated fairly, and you have the ability to negotiate that compensation amount.
Thank you. Next question. If you started behind in terms of salary and benefits in your initial contract, how can you close that gap in later negotiations?
Well, staying with the same employer, many times it makes it difficult to close that gap. But again, this rolls back into the know your value, know what's usual and customary, know what the compensation being paid for your specialty in your geographic location is. And one of the things that we see that also affects what that compensation is if you're with a private practice, if you're with a multi-specialty group, or if you're with a hospital-based organization. Each of those typically have different types of compensation. So it's important to look at what's usual and customary, look at what other people are being paid, and use the data, use the facts to help negotiate your compensation. If you start off behind, get that information so that you can use that as leverage to negotiate the appropriate compensation package.
Great advice. This next question is related to hours and schedules. Is it possible to negotiate for 80% of full-time hours, or is that a non-starter with some employers?
That varies from employer to employer and depends on the employer needs. I will tell you that we quite frequently negotiate for less than a full-time, but understand compensation adjusts with that also. But that's one of the things that you need to discuss in the interview process. Find out what the employer's expectations are and understand what your goals are. And so let's see what we need to do to make those two match.
Thank you. We have two more questions. And again, if anybody has any open questions, please use the Q&A feature. Next question is, do hospitals look negatively on a candidate for hiring an attorney to handle contract negotiations?
Absolutely not. In fact, I think most of the time they welcome it because especially someone that's well-versed in physician employment agreements, because they know what's usual and customary. And I will tell clients on a routine basis, if they're asking for things that are not usual and customary, I will tell them that this is going to hamper your negotiations. And so we find it that when we're dealing with medical practice, hospital-based organizations, that when we get involved and they know that we understand what's usual and customary, it usually facilitates it and gives us a better ability to negotiate those things which are truly important to you.
Appreciate it. The final question, unless someone else pops up, is can you negotiate the scope of a non-compete agreement? Does a non-compete apply if my employment is terminated without cause?
Yes to both of those in some circumstances. So there's always that little caveat on it. So can you negotiate the scope of a non-compete? Absolutely. But again, this comes into what the employer's needs and concerns are versus what your needs and concerns are. One area that we negotiate routinely on the scope of a non-compete is if you're providing services at more than one hospital, are all of those hospitals or all of those practice sites covered by the non-compete, or is it limited to the one where you primarily provide services? So that is one thing that we negotiate on routinely on a non-compete. And then the second part of that question was, does a non-compete apply if the employment is terminated without cause? Well, this is where it's critical that we review the non-compete and determine when it is applicable. Many times the non-compete in the contract will say that for the term of the employment and a period of 1 year following termination for any reason. And if it has that for any reason in there, then yes, it does apply if it is terminated without cause. That's where it's critical that we pay very careful attention to the triggering aspect of the non-compete and the exceptions to the non-compete when we're negotiating that agreement.
Thank you. That's very valuable. And that, unless anything else pops up, was our last question, and brings today's program to a close. I want to thank our audience for participating and for asking your questions. Trey and I appreciate it. If you haven't already, please take a moment to jot down Trey's contact information on your screen or scan the QR code to connect with Trey on LinkedIn. And that's it for today. We thank everybody for participating, and we hope to see you again next time.
Okay, thank you, Susan. Thanks everybody for joining.